My name is Josie Holland, and I represent the appellant, Joshua Wilson. I'd like to request 4 minutes for rebuttal, please.
All right.
This case concerns the denial of judicial diversion to a plea on a C felony tampering with evidence. Appellant Joshua Wilson respectfully asks this honorable court to reverse and remand the decision of the trial court for 2 reasons, both grounded in Tennessee's statutory sentencing scheme as well as case precedent in Parker, Electroplating, and King. First, the trial court failed to make the individualized findings of fact as required by Tennessee Code Annotated 4035-210B, as well as the mandate by Parker, Electroplating, and King. This vitiates the presumption of reasonableness that would otherwise be afforded the trial court's decision. Second, even if the trial court considered some of the required factors, it misapplied them, contradicting the record, general principles of culpability, and Tennessee case law. For these reasons, reversal and remand are warranted. Turning to appellant's first point, the trial court's failure to make individualized determinations on the record is a threshold procedural error. Both Tennessee Code Annotated 4035-210B, as well as Parker, Electroplating, and King, require that a trial court's decision to deny judicial diversion should be entitled to a presumption of reasonableness. But that presumption of reasonableness should only be afforded where the court considered and weighed the relevant factors on the record and explained its reasoning. That simply did not occur here. As this court has repeatedly held, beginning with Parker and affirmed in Electroplating and King, a trial court must do more than merely recite the existence of diversion factors. First, the trial court should identify the relevant factors, weigh them on the record, and then provide a reasoned explanation for its decision. And by saying this, appellant doesn't imply that there are any kind of magical words or that this recitation should be mechanical in order to be sufficient. Rather, there should be a meaningful analysis and a meaningful weighing of the relevant factors. King makes clear that without such findings, the presumption of reasonableness does not attach, and appellate review should be de novo, or the case can be remanded for proper findings. Here, the trial court did not meaningfully address the Parker and Electroplating factors. The record shows no individualized analysis of Mr. Wilson's amenability to correction, his social history, or the interests of the public and the accused. Instead, the court's ruling rests itself almost entirely on the concept of deterrence and the fact of that there was a loss of life. This is exactly the kind of reasoning that Parker and its progeny prohibit.
Would you agree that in its analysis, the trial court also considered the circumstances of the offense?
Well, the trial court, no, Your Honor, I cannot agree with that. The trial court...
Didn't the trial court, I don't want to put words in the trial court's mouth, but seemed to be bothered by the fact this was pled down to a tampering with evidence where somebody died, if I'm summarizing that, but basically was considering all of that, the fact somebody had died, and this defendant had pleaded guilty to the tampering charge.
Certainly, Your Honor, the court did consider that, but in considering that, the court is violating general principles about culpability, because we have an issue of self-defense here, where the deceased actually comes in to not only the home, but the very bedroom where Mr. Wilson was staying with a gun and threatening to harm him. So we have the victim essentially committing an aggravated burglary, and the appellant acting in self-defense. And pursuant to Granger versus State, a case from the 1800s, self-defense is a complete defense to the culpability in a situation where there is loss of life. And so in that regard, Your Honor, it shouldn't be considered a circumstance of the offense because the culpability for it is negated by the fact that it was an act of self-defense. And this is a point of fact that the state agrees with. There's a stipulation in the record in Volume 1, pages 27 and 28, where the state lays out some of the facts that we presented to the trial court at bench, which is that the deceased was on a lot of methamphetamine, enough to kill a horse. I don't believe that's the exact language in the affidavit, but the deceased was on an extraordinary amount of methamphetamine, making him highly aggressive. Two, the deceased had a history of being a drug dealer and criminal behavior. So the state agrees that this was an act of self-defense. And so for that reason, as a circumstance,
They agreed
it
that it was
can't.
an act of self-defense, or they agreed to those three things you just mentioned?
No, Your Honor, I believe the state agreed that it was an act of self-defense.
Okay.
Markeisha Washington, who was another eyewitness, who was also in the very same room.
I understand the proof, but the state specifically stated that they agreed that the defendant acted in self-defense.
In the affidavit that we drew up, I'm not entirely sure that we stipulated to that in particular, but that was the general implication of the reason that they were not charging him with second-degree murder once we waived it by information to the criminal court. Does that answer Your Honor's question?
So they didn't stipulate it, they just agreed these were the facts.
They agreed that these were the facts and that it was appropriate not to charge Mr. Wilson with murder.
So he was, basically, the charge comes from the fact that he left the scene and disposed of the weapon?
Yes, Your Honor. that
Because the
he
weapon
left
was
the
never
scene.
found, right?
Because the weapon was never found, Your
And
Honor.
that was the tampering charge that was agreed to and the information was based on?
Yes, Your Honor, and based on our self-defense argument, there's no aggravating circumstance here for which there should be a denial of judicial.
Get too lost. I thought he was charged with second-degree murder.
He was charged with second-degree murder in general sessions,
Okay.
and then he was, the event happens in September of 2022, so it's held to state on the second-degree murder charge as well as the tampering with evidence charge. After a period of time, the state contacted me. We made the decision to do an I waiver up to criminal court only on the tampering with evidence, and that they would not proceed on indictment with the second-degree murder. Does that make sense, Your Honor?
So he pled to an information.
He pled to an information. Turning to appellant's second issue in this matter, even if this court were to find that the trial court considered some of the required factors, its application of those factors was fundamentally flawed and contrary to both the record and controlling Tennessee precedent. Under Parker, Electroplating, and King, a trial court's discretion in denying judicial diversion is not unfettered. The court must not only consider the relevant factors, but must apply them in a manner consistent with the record and established law. So as in the case of general principles of culpability, established law would suggest that culpability cannot be found with regard to the second-degree murder charge. Critically, Tennessee courts have made clear that the denial of diversion cannot rest solely or even primarily on the seriousness of the offense or the fact that loss of life occurred, especially.
Now, the judge said several times that she wasn't denying diversion based on the fact that a person died.
Judge does say that, but that's really a surface denial. At volume 266, this is what the judge says. I am admitting on the record that you do meet the requirements, and I'm not deciding that you can't have diversion just because somebody died. I just think probation would be better for you. I think it would be a deterrent for the entire community to know that you can't just go around shooting people, even in self-defense. Your Honors, that is contrary to law. Individuals are allowed to act in self-defense. This is a stand your ground state. Here, the trial court expressly acknowledged that Mr. Wilson met all the requirements of diversion, yet denied relief based almost entirely on general principles of deterrence and the fact that someone died.
Well, didn't the judge also talk about the fact that your client was engaged in other criminal activity around this time? Trying to pass a stolen check?
The judge did mention that. She did not specifically state that she was denying diversion based on that criminal activity. And if she had, Your Honor, that would have been more in line with the requirements of 4035-210B and the Parker electroplating factors.
But she obviously considered it because it was discussed. And there was also the fact that he was possessing illegal drugs at this time. So it's kind of two criminal offenses that were occurring at the same time.
If that was the court's reasoning, it's not clear from the record. One of the requirements of Parker and electroplating is that the court puts its reasoning and the weight it's applying to these factors on the record. And it's not clear in this situation that that's what the judge was doing here. Tennessee courts have repeatedly reversed denials of diversion where the trial court ruled on the seriousness of the offense or the fact of loss of life without more. Looking at cases like State versus Sprang, State versus Teresa Turner, and State versus C. Panya, Sihapanya, those are cases specifically where this court has discussed the fact that loss of life is not enough to deny diversion. There are individualized equities that support diversion here, Your Honors. Mr. Wilson is a first-time offender. He has no prior criminal history. He turned himself in, and he's demonstrated remorse and a willingness to comply with the court's requirements. The pre-sentence report and testimony show strong family support and a stable home environment. Mr. Wilson has work history, and he's employable. He was working as a janitor at the time that he was petitioning for diversion. The pre-sentence report recommends interventions that are available and appropriate in a diversionary setting. No evidence that Mr. Wilson poses an ongoing threat to the community was presented, and facts support that his behavior was reactive and not a pattern of criminal behavior.
One of the other things they talk about was, which I think he talks about, is that he used marijuana daily.
He did, Your Honor. I believe he talks about the fact that he has bipolar, was without insurance, and was self-medicating through the use of marijuana. And while that is certainly illegal activity, again, Your Honor, had the trial court put that on the record, I would have no reason to appear before Your Honors today.
But my understanding, it's on the record. I mean, this is stuff that was discussed, was during the hearing. It was, this might have even been in, was it in the pre-sentence report?
That's where it was, Your Honor.
Okay. So all those things were available to the court to consider and were mentioned during the hearings. So you're saying that those were not considered by the court?
If those things were considered, we don't have it on the record, which is the requirement of Parker and electroplating. What weight did the court afford that behavior? The court never says, I'm denying diversion and placing you on probation instead because you've demonstrated that you've engaged in other criminal behavior outside of this incident. The court never says that. And if the court had said that, there would not be a procedural issue here for which the appellant could seek reversal. In sum, Your Honors, this case presents both a procedural and a substantive failure on the part of the trial court. The court did not make the individualized findings required by the statute 4035-210B and Parker and electroplating. It relied on impermissible considerations as controlling weight. The law is clear: without proper findings and a reasoned individualized analysis, the denial of judicial diversion is not entitled to deference. This court cannot provide the trial court's decision with deference. The record here supports Mr. Wilson's eligibility for diversion, as there are no aggravating factors that would justify the denial under Tennessee law. For these reasons, we ask this court to reverse the denial of diversion and remand for proper application of the law. Thank you.
Counsel, real quick, I was looking back through your brief. You repeated it several times, the general principles of culpability. Are those your words, or is that from a line of cases?
The general principles of culpability, that's my vocabulary, Your Honor, but I do refer to Granger versus State, which offers that, Granger versus State, Grainger, which states that self-defense is a complete defense. And of course, self-defense is codified at 3911-611 under the Tennessee Code Annotated. If there are no further questions, I ask that this honorable court reverse and demand for both procedural and substantive failures. Thank you.
Good afternoon, Your Honor. Kirby May on behalf of the state of Tennessee. This court should affirm the trial court's appropriate and proper denial of diversion and granting probation in this matter. The defense appears to focus so much on the culpability and the self-defense. Well, again, after being finding probable cause at general sessions of second-degree murder and tampering with evidence, the state and defense agreed to an information on tampering with evidence. The culpability of defense for self-defense goes to the second-degree murder charge. And a trial court can consider at sentencing the circumstances of the offense, which is what happened here. It considered both what happened leading up to the offense that led to the tampering, as well as the events that happened after as they left. One of the things that the trial court did find, and the record it shows, that the trial court considered the relevant factors for diversion and explained its reasonings, which is what's required in electroplating and in Parker. It pointed out several factors that weighed in the defendant's benefit: his prior employment, his family support, and what the court found was amenability to correction. However, it weighed that against what it found, the circumstances of the offense, and the need for deterrence. And it weighed those factors. It was very clear in the record from about 61, volume 2, 61 to about page 70.
What was the trial court saying needed to be deterred?
It focused a lot about the prevalence of firearms and the use of firearms in the community.
And so she's against the use of firearms in self-defense?
Well, what the Judge Blackett referred to, it was not just in self-defense. It was just a general concern of the use of firearms and the active use of firearms, whether in I think she actually used the words whether in self-defense or otherwise, the use of firearms in the community. And that was a consideration that she did place on the record. However, that wasn't the only consideration. And the defense...
All right, do you acknowledge then that is not a valid consideration?
Well, it's a consideration in regards to the tampering with evidence. Your Honor, as you recall, he used the firearm, fled with the firearm, and there's also the allegation from the record. Again, the record as to the facts is limited, except for this court has the defense presented at the hearing, the audio from the preliminary hearing, as well as the recitation of facts at the plea part of the sentencing hearing, is that the allegation from the defense was that Matthew Harper, the victim in this, the decedent here, was armed with a firearm. But there's nothing in the record that indicate that the firearm was recovered from Matthew Harper. There was some sort of holster, but no firearm. So the concern is from the court was that the defendant took his described as an AK-style firearm, as well as appears to be the victim's firearm from the scene. And I think that was part of the court's concern, and as it discussed in that section of its opinion as to its determination whether to grant or not grant diversion. Again, it granted probation. It granted an alternative probation, and the plea agreement was clear in this, that the state and the defense agreed that the defense could seek alternative correction, whether probation or diversion, and that would be left to the court. And
I want to ask you about that. What's the context of the statement, the state's statement, defendant is a great candidate for either diversion or probation? What was the context of that?
Well, it appears from the record that the state presented that the state was not seeking incarceration. That, I believe that was the position from the state, is that it was not seeking incarceration, but it was allowing the court discretion as based on the record that was presented to it. Because remember, you had the testimony, and you had the pre-sentence report, which included some positive things for the defendant, but also pointed out active drug use both before and while on bond, that up to 3 times a day using marijuana while on bond. It also included a reference at the hearing from the defendant that while in custody on this, they had physical altercations while in custody. All those are things that the court considered, and that was part of the record. And
Was
it's
the
also
statement at the plea or the sentencing?
it was the sentencing and plea were one day.
Okay.
And the defendant testified at the sentencing hearing and conceded those things, as well as they were in the pre-sentence report. And all those support programs that were recommended in the pre-sentence report were also available during the defendant's probation. And the court also considered one thing in its noticing that some things that were the positive things that were in the defendant's favor were that he had those support. And so it did consider the positives, and then it weighed those factors with the deterrence and the circumstances of the offense, and it found those two outweighed the positive factors. And so it did the balancing, it did the consideration, and it put that on the record. And then by doing that, there's a presumption of reasonableness in that. Another thing the defense expressed concerns about in its argument is the comments regarding the court considering the death of an individual. And there are other cases, but this court in 2023, Sheets and in Wells, both opinions from 2023, were in Sheets when considering the circumstances of the offense, the trial court may consider in a way circumstances leading to the death, which the court did here. And in Wells, a 2023 case from this court, a court may also consider in a way circumstances immediately succeeding the death and the impact of the death on the family. And again, the court made reference to those things. And as long as the court doesn't base its opinion and its decision solely on the death, it can consider that in its factors that it consider in weighing of whether to grant diversion or not, or other alternatives. And it still did grant probation. It found that he would be a good candidate for probation.
On the diversion, counsel, could you give me a couple instances where the trial court weighed the factors against each other?
Yes. It said specifically that in page 63 of the volume 2, it pointed that the favor of the amenability of correction, the lack of a criminal record, and the strong family support. That it weighed those are the positive things it weighed.
So it weighed by considering the positives and then addressing, I guess, the negatives. That was the weighing against each other?
Yes.
Okay.
And based on that, this court should afford the presumption of reasonableness to the determination that probation was the appropriate sentence here, and diversion and the denial of diversion. And based on that, this court should affirm that decision. However, if this court finds that the trial court, Judge Blackett, did not lay out sufficiently each of those factors, this court has substantial record in this matter to look at and consider, and would again affirm and concur with the trial court's determination that diversion was not appropriate in this instance. And the state is asking this court to affirm the trial court's judgments in regard to the denial of diversion. Thank you for your time. If you have no other questions, I apologize.
There are some points that definitely need clarifying here. Under tampering with evidence, any defendant who alters, destroys, or conceals any record, document, or thing in order to impair an investigation or its availability as an investigation is guilty of a crime. So in this situation, Mr. Wilson admitted that he left the scene. Mr. Wilson did not admit that he took the deceased's gun, though his brother was granted immunity from that. And certainly there are some factual surroundings where a jury could have determined that and would have convicted him of tampering with evidence. But the fact is that he left a crime scene. And that was why the appellant conceded to the tampering with evidence charge, because it is undeniable that he left the scene of a crime and that alone could be considered as tampering with evidence. He did not admit that he took the gun, and he did not admit that he did anything to do anything to the scene to prevent the police from figuring out what had gone on. And as the state points out, a court can consider what happens immediately prior to the offense. And if we're considering that, Your Honors, we have the deceased coming into a residential apartment complex armed with a gun to try to get his drugs back, which he had accidentally dropped outside his door. And he threatens not only appellant, but also a young woman who is in that apartment complex. And the circumstances leading up to the situation indicate that appellant should not be found culpable, that there's not an aggravating factor that this court should find.
Let's back up even farther. I think this whole kind of interaction started, first of all, your client knows that the deceased is a drug dealer.
My client does not know that. He's only met him on the day of September 11th.
Well, he
He
said- yeah,
comes
he-
to find out that excuse me, Your Honor, may I?
The decedent asked him to pass a bogus check or a stolen check for him.
The decedent asked him to cash a check for him
And
at
he tried to,
Scooby's.
and he tried to.
He tried to, but he did not necessarily understand that that was a bad check. I believe that the decedent had represented that it was his paycheck. That part of the record is not totally clear. Yes, Your Honor, there's an issue with that, and of course that is a circumstance that the court could have considered. But when the state says, well, the court clearly weighed the negative factors against the positive factors, we don't have the court saying, well, he got in trouble while he was in custody and he's smoking marijuana three times a day.
Let's go back to that a second. What exactly does the court have to say? Is there magic words the court has to say in order to satisfy these cases?
No, Your Honor. Of course there are not magic words that a court has to say, but there has to be meaningful analysis.
So,
And the court's analysis in this is not individualized, nor is it meaningful. If the court had said, he's done these bad things, that's the reason I'm not granting judicial diversion, well, then Your Honors would afford that a presumption of reasonableness. But the fact is that language is not in the court's oral ruling. The court never says that I'm denying diversion based on these bad acts or based on the bad check that he tried to cash. And if the court had said that, there would be a presumption of reasonableness afforded, but this court cannot afford that presumption of reasonableness because the court's reasoning is that I think it would be a deterrent for the entire community to know you can't just go around shooting people, even in self-defense. And Your Honors, that is patently against the law and abuse of discretion. We ask that this court reverse and remand for procedural and substantive error. Thank you.
all right, thank you. Y'all need a break?
I'm good, Your Honor.
I'm fine.
All right. Call the next case, please.
State of Tennessee versus Reginald Jenkins.